Be ready. Start. An FIR is to be drawn up under Section 154 CRPC when an information relating to commission of a cognizable offence is given to officer in charge of a police station. If it is given orally, it is to be reduced into writing and is to be read over to the informant. Every such information of commission of cognizable offence is to be signed by the person giving the information, and the substance thereof is to be entered in a book to be kept by the officer in such form as the state government may prescribe in this behalf. This is popularly known as the FIR. Loading of the FIR no doubt requires information relating to commission of a cognizable offence, but it nowhere requires that any particular person be named as perpetrator of the offence. It may not, therefore, be proper to describe an FIR to be untenable in law simply because it names as corporate person as an accused. The case law that has been relied upon does not cover the instant point. Here was a case before the Supreme Court in which, in a prosecution under Section 138 of the Negotiable Instruments Act, the accused was acquitted by the magistrate on the ground of absence of the complainant. The complaint was, however, filed by a company and was not a corporeal person capable of making physical presence in the court. The Supreme Court observed that where the complainant is a body corporate, it is de jure complainant, and it must associate a human being as de facto complainant to represent the company. In the case of absence of a corporeal representative, the company could seek permission of the court to send another person to represent it. Para. In the instant case, it appears that the revisional court was not satisfied with the manner in which the evidence on record was assessed by the trial court in not taking into consideration various important aspects of the matter. In such circumstances, the revisional court should have remanded the case to the court for a fresh decision instead of reappraising the evidence itself and substituting its own finding of fact. Learned counsel for the respondents, however, argued that in the written statement the defendant has not specifically denied the averment made in the plaint that a notice was duly served upon the defendant, and none of the courts below have taken into account this important factor while answering the question of service of notice. What is the effect of the pleadings of the parties in the present case in the light of evidence on record has not been considered by either of the courts below, and this court in its writ jurisdiction does not decide a disputed question of fact. In the present case, on one hand, the revisional court has acted beyond its powers in substituting its own finding of fact for the one recorded by the trial court after reappraisal of evidence, but at the same time it is also clear that the trial court did not appreciate the evidence adduced by the parties on the question of service of notice in its right perspective, and it also lost sight of the fact that the observations made in another suit with respect to the statement of the postman who was produced as a witness in that case were neither relevant nor could be read in the evidence in the present case. If a witness is disabled in one case, it does not mean necessarily that he is a liar forever or that his evidence is to be discarded on that ground alone. Stop.